Good afternoon, everyone, and welcome to Universal Furniture. I'm Kayla Miller, the Director of Marketing here at Universal. Before I hand it over to Wendy, I have a few things I would like to highlight about this market. So we've introduced two new collections this market, Dwell, as well as in addition to our modern collection, and Dwell's located on floor 2. The modern edition is located on floor 3. While you're here in the showroom, you can stop by the front desk and check in. You can get a scanner, go around our showroom scanning all of your favorite things, and then you'll get a wish list emailed to you with everything that you scan while you're here in the showroom. We also have a designer's lounge that's located out in the lobby. You can get a swag bag if we have some left. Not 100% sure that we do, but definitely stop by and check. You can get a hair touch-up. It's by appointment, but I think there's some walk-ins left if you want to stop and see if you can squeeze one in. You can grab a drink. I think they just opened a bottle of champagne, so you can get some champagne in there. And also, it's just a place to connect. We have Wi-Fi. You can catch up on emails. If you need a place to meet with a client, it's a dedicated space for designers here in our showroom. And I just want to thank you again for coming by and seeing us today for our educational event. And now I'm going to hand it over to Wendy if everybody wants to give her a warm welcome.
Thank you. Thank you so much. Thank you, everyone, for coming at 4 o'clock on Sunday. I appreciate it. I promise it will be very entertaining and fun. Sure. It's contracts. So my name is Wendy. I'm an attorney. I'm a business attorney. I have been a lawyer for 24 years, almost 25. For most of my career, I was in the construction industry, working for a big company in-house that built power plants and worked with a lot of subcontractors and all of that. I worked at Otis Elevator Company right out of law school. And then I, at one point, moved into working at a law firm. And in that time, I've started to represent a lot of interior designers to the point now that I have like 100 clients. And it's people from just starting out to all the way up to AD 100 El Decor A-list. So I've seen all these issues, and I can tell you everyone's the same. Like, you all have the same issues, basically, from struggling with imposter syndrome sometimes, to dealing with I'm not going to use the word crazy, but you know what I mean, those clients, to dealing with disputes, to dealing with, pricing and how to best set up your contract. So I have a lot of experience with this, and hopefully you get a lot out of it. I will tell you this also, I'm happy to share this presentation afterwards, so if you're taking notes or trying to take pictures, I'm happy to send it to you, so don't worry about that. At the end of it, there's a checklist for you to review your own contract to make sure there's everything in it that should be in it. And the last thing is that if you are trying to get CEU credits, this is for credit, but you have to sign up with me at the end of this. I was not prepared enough to get the QR code, but I have the paper, so just come see me after. Or if you have to leave early, I'll just leave it on a chair. I won't be offended. Just put your information on it. So, okay, so with that, before we get started, I want to know, how many of you use a contract? Okay, so just about everybody. That's good. Who bought their contract as a template online from either a coach or just online somewhere? Okay, yeah, and then this is the other category, who basically put their contract together based on what they got from their friends, and it's basically cobbled together? Yes, I knew it. Okay, that's everybody. And it's great because you have such a nice industry and there's a lot of camaraderie, but the issue I find there is that I guarantee if I went one by one through the room, no two of you work exactly the same way. I have yet to see two designers that have the exact business model, okay? So that's the issue with kind of putting the contract together based on what your really successful friend does, because you end up not really knowing what's in there. You might know what's in there, but it works for them because of, the fact that they, it's for their business. Let me just keep going here. So some of the things we're going to discuss today are why you need a contract. I'm sure you have that figured out. Essentials to include, why the template is good but not the best situation, the format that I recommend, the process you should follow with your client, and the style of the contract. The importance of the page turn, which would be talking to your client about the contract. I just got off another panel and we were talking about how it's so easy to email it and just hope that they sign it. I get it. I mean, even as a lawyer, I don't love confrontation, and I don't litigate. I only do business stuff. So If I think there's going to be a contentious situation, I'm an avoider. I totally understand it. So, but that's not really the best way to go, and you have to force yourself to interact with these clients about the contract. Spotting red flags, and then Q&A. That said, if you have questions, please just ask. Like, just raise your hand, because I want this to be interactive. And there's really no bad questions. So, okay, so contracts. It's contracts and relationships. And I always say that when you have a new client, you have to ask them if they've ever worked with an interior designer and how did you enjoy the process. And there's obvious reasons. You want to know what they know, and you want to know what their experience was, and you probably want to know who the bad designer was that they worked with and what happened, and I get it. But like more, so then you want to listen to them and like how they talk about the designer and all that. But more importantly, and the way that I explain this question now has changed, like I said in the beginning, these clients, like they could have worked with another designer who's good, but that designer does something different than you do. So you have to basically erase the brain of your new client and say, that's great that you worked with XYZ person who, moved out of state and you had a great relationship, but they're no longer available. Tell me about how she worked, okay? And let me tell you how I work. It's a little bit different. I charge this way, whatever. But you've got to really think like that client has a whole set of expectations based on the process the other designer used, the way they communicated, whether they took text messages. Some designers won't text. All of those little factors that make up that relationship. So you have to really listen to that, and you have to find a way to literally like erase the brain of, of what that client has in there. Because you're going to fill it with new information about yourself. So the things that are important and the reasons you need a contract are to protect your legal rights, to outline your obligations and also limit them. So you're telling the client what they have to do, they have to pay you, what to expect, but anything you put in there, you also have to follow. So for example, we were talking just recently on another panel about if you say that you're going to mark up product like 40%, and then it's more like an average that you do 40%. Some things are like fabric, it's way more. Something else you're marking up 12%, but on average it's 40%. If you get into a dispute with your client, they're going to check to make sure that everything is marked up 40%. If it's 42%, you've now breached your contract. If it's, so everything that goes in there, it's not just something to protect you, it's obligating you to things too. These are obligations you have with each other, okay? Setting expectations. So we talked a little bit about the communication, but one thing that I've recently started to do with the expectations is this. In your contract, you're going to talk about photography, right? You're going to say, that's a really important thing. Who is it important to in this room? Please raise your hand. Yes, okay. So one thing that I've recently said with this is that at the beginning of the contract and the relationship, you're going to sit down with the client and figure out if they're a good client for you, not just the other way around. And they're going to say, well, what's your fee structure? And you're going to say, well, I get paid based on my design, procurement, execution, whatever it is, flat fee, hourly, whatever. But in that conversation, you should also say, and a very important part of this deal for me is photography, and this is why. And you're going to talk about it at the same time you talk about your compensation, because it can be one of those things that is so important to your career. This might be the project that you're photographing that is going to be in a magazine. It might be a whole house that you're spending so much time on. You need to set the expectation with the client that that's part of your deal, okay? If you don't do that and then later on they take it away from you at the end because they're just, fatigued from the project, or they don't want to do it, or they tell you at the end, well, I didn't really realize you were going to be in here for 3 days, and that's like my privacy, whatever. When they take that away from you at the end, that's one of the most common phone calls I get from my clients. Like, they're telling me they're not going to let me photograph the project. Okay, so what happens at that point? Are you going to go to court and get a judge to allow you to go into that person's house to photograph for 3 days, even if your contract really clearly says you have that right? No. And there literally was a judge in one of my my presentations today. She's the mother of a designer. And she's like, I'm so glad you said that. Because, yes, there's no way. So you have to actually set it up, and we'll get into what you do here, but so that if that thing doesn't happen, you're going to get compensated, okay? So you're never, even if your contract's crystal clear, you're not going to get the photographs if they don't want to give them to you. You can get money, though, okay? So you've got to find a way to get compensated for what you just lost. And that might be $5,000, it might be $25,000. So we'll talk about that. But that conversation is critical to have early on because the clients never understand the importance of the photography. They just don't. You're going to define and explain your process. So you probably have some really beautiful marketing materials that you give to your client ahead of, giving them a contract. That contract should also high level capture what you've already told them. And I really try to have the contract even look like the marketing materials. So oftentimes I see this really beautiful stuff with photographs and everything, marketing materials. Then the contract that you guys send me to review is whereas, now therefore, inter alia, all these words, right? And it's it doesn't match what you've just been giving them. So you've brought them down this path with this beautiful stuff, and then you just dump this legal document on them. And it's not good because they're going to just stop paying attention. You had them until that, right? So what I try to do is get you to almost take that marketing material and carry it through into the contract. And then also, again, summarize what you already explained to them, define your process, because again, you are bound to that and you can bind them to it, and then kind of flow into the legal stuff. Boundaries. That's self-explanatory. There's also an exclamation mark because I'm really bad with them, I get it. You are going to explain how you are contacted, what your business hours are, that kind of thing, how they can contact you, when you have to respond, what the relationship looks like. And also, if you have a really bad client who maybe pays perfectly, they pay on time, but they're treating you or your staff so poorly that you're going home crying and you hate these people, that's not good for you. And this might not be this is outside of the legal discussion, but don't keep that client because you're gonna have a point down the road where you're why am I even in this business? So you wanna figure out in the document, yes, what the boundaries are, I can fire you if you're terrible, but even before that, you need to figure out for yourself what's a good client and what's a bad client, and you gotta write it down because I talked to someone last night who was literally in tears about a situation that was all boundaries. So figure it out ahead of time, and I'll tell you how to deal with it in the contract. Limiting your liability. That is when you say to me, I need to make sure that my contract protects me, right? That's what it is. I mean, liability is how much you can be sued for, right? So the rule here, and we'll talk more about it, is that if your design contract has design fees of, say, $50,000, the max you should be sued for, if everything goes wrong and you really screw it up, is $50,000. You shouldn't be in a situation where you're getting sued for $350,000 if the deal was a $50,000 deal. Now, it's very important in any contract to have, but in particular, if you're doing a commercial project, and that's the client's little side business. The client has a coffee shop. The client has a doctor's office. You're doing that in addition to the residential project. Totally different types of contracts because commercial and residential. The liability limits are different. And in a commercial project, you can get sued for the lost profits of the business if they're not opening on time because you delayed them. So that limit of liability is very important to state, and you put a dollar value in it. So I'd say 50% of the contracts I see that are just pulled from the internet or cobbled together or whatever have that language, but there are ways to improve it, which you will learn today. Shifting risks is that whole section on indemnification, insurance, even schedule. So how about this? Are you responsible for delays caused by hurricanes, like what's going on right now? If the furniture manufacturer is completely destroyed, or if the ship that was shipping your items over from India sank, what happens? Who's responsible? It's clearly not you. These are things that are called a force majeure or an act of God. We shift that risk and say, it's not mine, so I'm shifting it over here. It's also, technically it's not even the client's risk, but we're saying it's nobody's risk. And in that case, we both have to pause and realize this was outside of anyone's control. So I'm not going to get in trouble for not delivering on time if there was an act of God. And you also, client, are, it's not your fault, but we just have like a pause here, and you excuse the fact that I can't do what I was supposed to do because it was out of my control. You're going to use the contract to determine how disputes will be resolved. I'll talk a lot about that. I'm not going to talk it all now, and much, much more. So now we get into like the details. So the contract, the pricing is very important, obviously. I can't really get into too much detail about how you price, right? Because there's so many different ways to write it, okay? But most people are doing either an hourly, a flat rate, or like a hybrid, flat rate design fee plus hourly for execution, and a markup. So it's some sort of combination of that. Whatever it is, it's got to be explained very clearly. And so you have to make sure the client understands it. So you can write everything and you could think you have it covered, but unless you're sitting there talking to them and they're nodding and they can actually repeat back to you how it works, that's the test of whether they understand it. And most of the disputes come from clients being surprised by pricing, or like halfway through the project, wait, you need more money from me, you need another retainer, or wait a second, I spent all this money and I only have this design, I thought I'd have more by now, or whatever it is, you have to make sure they fully understand it. And just one little additional side note, if you're doing flat fee, when you explain the pricing and you have a scope of work, in your scope, you've got to be crystal clear, because those clients are expecting like the all-you-can-eat buffet. They want flat rate, it's all included. So you have to have a section, no matter how well you explain what you are doing, most importantly, you've got to explain what you're not doing for that fee. So at the bottom of your scope document, you're going to say, work not part of the scope, and list it. And think long and hard and put everything on there, because that's what's going to trigger your ability to get a change order, amendment, whatever you want to call it. And any of that out of scope work you should be charging hourly for, unless you do negotiate another flat rate. But in reality, it's hard to negotiate that flat rate because it takes time. It takes time to sit there and haggle with them. So default to hourly. And then if you can figure out flat rate, fine. But in the meantime, you're tracking your hourly time, you're collecting it, and you're starting to send them the bill. The other thing with pricing, and obviously you have all this other stuff here I'll go through in a second, but like these are like the big takeaways from me. You've got to bill regularly and like on time. So if you're doing, especially if you're doing hourly, okay, you cannot bill, like, let's say just the start date is January 1. You can't send your first invoice on like February 15th, because you're now way too far into it. And you're giving them the ability to say, wait a second, I'm just getting my first invoice now. Whoa, I didn't expect you to be billing me this much. This is like really unacceptable. I thought it was gonna be less. For hourly, you bill at least once a month, preferably twice, like every 2 weeks, so they know what you're doing. You're probably giving them a projection of time, but some things are not the estimate, and they know that, okay? But you don't want to give the client any ability to really, question how you're working, because that's where they get the power in a dispute. Do you have a question? No. Okay. All right. So in addition to the pricing, like flat rate hourly, procurement, everyone handles it differently. Everyone. I will tell you my recommended way to do it, and mine is from the view of someone who's resolved a lot of disputes between the designer and the client, okay? And I know what they come back with. So if you're doing, there's really not like a wrong. I was just sitting with Shamin. I don't know if you guys know Shamin Taylor-Smith. She's like a coach, and she and I are very much aligned on how all this should work. And she'll say, you should never be exposing what your markup is or how you do this pricing. You should just send the invoice. I, in my experience dealing with all these designers, know that it's not really how it works. I get what you should do, but I know the reality is some people are not marking anything up. They're just passing through. I'm not going to ask for hands or anything, okay? But there's that. Then there's on this end, there's people who are just saying, this is the price. This is the price. I'm no different than Pottery Barn. I'm not telling you where I got the thing. This is the price. Really, in the middle is where most of the other people land, okay? And so if you're in the middle, you're either saying, I charge 20% or 40% over my price, okay? Or I charge retail, or I charge I charge about, anywhere from 10 to 30% less than retail. It's something like that, okay? Of those options, my recommendation is to say, you've got your retail, I'm either charging retail or a discount off retail, and it's a range. And the reason I say this as a recommendation for that middle ground is because when you have a dispute with a client, no matter what it is, they start looking, they're throwing everything at you. They're throwing the kitchen sink at you, as they say. And their lawyer, because they're gonna read your contract and realize, my client does owe all of this money, so they start looking for anything. They will say, please provide me every invoice for every piece of furniture or item that you've ordered and show me the markup. And now, theoretically, okay, you didn't do anything wrong, you're providing it, but in real life, that is a huge burden. You've got somebody in your office pulling every invoice. Now you're showing where you get the stuff from. You've got to prove it. It's like being audited by the IRS. You don't want that. If you say it's a discount off retail, in most situations, that other lawyer can access that retail price, and they can just look at the invoice and just prove it themselves. You don't want to have a situation where the dispute is creating so much work for you that it pressures you to give in and give the client who's being demanding and trying to get something from you in a fight. You don't want that to be the pressure that gets you to cave, okay? So that's just something I've seen in my practice, and I recommend that. Question?
So I have a background in retail first, and so as a retailer, you have keystoning, then you have what no one should be doing keystoning anymore, but where the old process was you take the cost times 2 and double it, and that's your retail price. Now we have MSRP, and sometimes that, for some companies, that's a 3-time markup, sometimes it's 2.25. So when you're saying discount off retail, because my contract says we charge reasonable retail.
That's fine too. Reasonable, as long as, but it's still asking a question.
What retail is, and that's where my question is.
I get it. It's not perfect.
I mean, does the attorney, is he able to go, your retail is actually a little bit higher than retail from someone else?
Who determines it is whoever's settling the dispute, whoever's resolving the dispute. But the point is, you don't want to do anything tied to a price you pay, okay? Because now you have to show what you paid. So that's just an administrative burden. You've got somebody in your office spending an entire day that you can't bill to anyone, pulling together invoices. So if you tie it to a retail or something, look, there's some things where you're setting the price. If it's an antique or handmade item or something like that. The idea is just to get it away from something where you're going to be burdened with having to produce all of this, because that's the reality. And when that request comes in, the eyes are majorly rolling. You know what I mean? Like, oh my God, we have to do this. So.
Is it possible to put in there that if they're requesting that, you are going to put administrative time to that?
Yes, but in reality, you can have that written. At this point, you're already fighting with somebody, and you're getting towards a settlement. Yeah, and you can be entitled to that, but in reality, if your client is saying, well, I'm not satisfied with your work, I want $10,000 back, and and now you're fighting over $10,000, great, it's written in your contract, they're gonna pay your legal fees or whatever, but you're settling it now through a negotiation.
The administrative, we provide all of our stuff up front so people have it, but when they come back, we've typically said, I charge a fee to present all of that nice, neat little package for you since you're asking it. And they will pay it, and then they stop talking after that.
Right. Well, all I'm saying is if you're in a dispute with them already, like something that looks like litigation or leading up to litigation, it's very hard to send an invoice and be like, okay, we compromised on an amount, but here's the bill for the time that I spent to pull it together. They're gonna say, we're not paying that. This is the amount. Sadly, it just comes down to negotiation, and that's the reality of, in 1 second, that's the reality of these design contracts, is that everyone wants that thing that's gonna win in court. But guess what? You're not going to court, okay? I mean, very few of these contracts are going to court because the dispute is like a $50,000 or under dispute. You know how expensive litigation attorneys are? It's like $15,000 just to get them to look at your matter and get started. So if you're trying to collect or you're trying to defend, fight over a $30,000 issue, it's a negotiation between your lawyers. It's not going to a judge, it's not going to arbitration, it's a negotiation. So all these little things matter, okay, because you're just are not fighting it out in court. So a lot of my comments are based on that. And by the way, you don't want to fight in court because if you go to court, it's public. So do you want to be the designer that everyone can Google and read the case about and be like, oh, she got sued? And guess what? Everyone's talking about it. And even if you got sued for BS, frivolous reasons, you were the designer that got sued, and that hurts your reputation. So I put into all these contracts that your disputes have to be resolved outside of a court, and while you're resolving disputes, nobody's disparaging anybody, and everything's confidential. That is worth everything to your reputation. And if you don't have that, and now you've got a client who let's say you're holding all the money, and you're like, no, I'm not giving the money back. And Wendy said, you're not gonna come after me because it's only $15,000, and they won't, okay? You're now holding the money, you're not giving it back. They're gonna go online and Google review the heck out of you. And that's how they're gonna get back at you. Even if you have the right to hold the money, everything. So all of that confidentiality stuff is important because when I get on the phone with the other lawyer to try to negotiate this, I say to, like, they know, they've already read it, and they're like, oh, my client can't do this. They can't, you know, so these are tools in a fight because most of these issues get resolved through these negotiations, and there will be lawyers involved that do the negotiation, and when that stuff is seen, it's like you just took a bunch of like weapons away from the client, you know, including just taking them out of court. I have one question right here. Yeah. Mm-hmm. If your contract says that you don't have to, you don't have to. And really, it's not going to say that you have to give it. And if your definition of what's considered confidential in your contract is strong, that's covered. So you don't have to give it. I say that your vendor relationships and your vendor pricing is private to your business, is confidential. And that's what makes you competitive. Like, would you want to publish that so your competitors could see it? You don't want that information to get into the hands of anyone, including your client or, you know, other designers that you're in the same circles with. You don't need to share who you buy from, what you pay, what your discounts are. I mean, that's what makes your business unique. You know, and that's like the secret sauce. So you're not giving it to the client. Why should you? They just want it because a lot of them just they have a misunderstanding of what you're actually doing because they really just want the cheapest price. And that's where the communication comes in and them understanding you can make money on this deal and you're going to make money on it. But they don't understand it. So, question?
I just wanted you to repeat, disputes need to be handled outside of court, and the disparity part is,
Non-disparagement. Yeah, I have it in my checklist, you'll see, but it's basically what I say, and you could write it down, is during a dispute, neither party will disparage the other online or in any forum. Because here's the idea, you're trying to resolve a dispute, so it's so counterproductive to go trash each other online. Like the idea, it's a reasonable provision to agree to. Okay, I've had clients of my clients that will cross out language that says nobody's gonna disparage each other ever. Because they're like, well, what if you do a bad job? I wanna leave a review, right? I know, that's a red flag. But if you limit it to during a dispute, the only time they would do it is during a dispute, so you're covered. So you have to have that in there because there was one lady, I don't think she's here right now, but she reached out to me, one designer who's been around for a long time, and she had an issue, and the client just went, not only reviewed her, but the client got their family members to review her. She had all these, like 2-star review, really awful. And to the point where she got a new client, and she met with the wife, and the wife was like, oh, I love you, I want to move forward. And her husband came back from like a weekend away, and he called my designer client and was like, I'm sorry, we can't move forward. I did research on you, and I read the reviews. And she called me like just crushed. And this was like a complete BS. But what happens is these are as you know, like there are a lot of good clients, right? But when you find the bad one, you know who they are, okay? And when it goes south, they completely turn on you. And when they realize you've taken away some of these tools, like, they can't go in court and like publicly fight you, they really resort to anything. And sadly, they try to destroy you. I've seen it time and time again.
So can she then sue that client for
Defamation?
defamation?
Well, here's the thing. Defamation has to be a false statement, right? So if it's just an opinion, I think that this designer's unethical. If it's your opinion, that's not defamation. Not to mention, defamation cases are very expensive and they're hard. You have to provide like very specific proof, but opinions are not defamation. So think about how you could write an opinion review and get away with it, So and we know that these, especially design businesses, Instagram, Google reviews, it's your lifeblood. So you got to protect it. I'm just going to keep moving because I'll end up talking for like 2 hours. So anyway, markup, expenses, you can just say reimbursable expenses are paid by the client, and then you create a definition for that, and it's whatever you think it is. But it's everything. I mean, you could put your CAD drawings in there if you want. You could put whatever as reimbursable. You can have a separate travel policy. Just make sure it's clear to the client. Another thing, the clients do not understand shipping, receiving, and local delivery because they are brainwashed by Amazon and free shipping. So you have to explain it. You have to explain exactly what a receiver does. They don't know. I did not know until I started working in this industry. And also when I moved into my own house, I like to tell this story because this is exactly what would happen to a client. I ordered my daughter one of those like mirrored vanities, those like with all the lights like crazy. So I ordered it from like some website where they ship it directly to you. So it gets delivered to my house in a crate. Like it takes up my entire garage. I'm like, what is this? I had to hire someone to come and take it apart. They take it apart. The bench is all cracked. I'm like, oh, now what? So I went through the experience that a client would have if they said, just ship it to me. They don't know that the receiver takes care of all that, right? So you have to explain it. But for me, that was huge. I didn't know, and I'm, an above average intelligence person. I still didn't know. So you have to explain it to these clients because they don't know. And you're with each other. So you all speak each other's language, and you have to remember that the people that you're selling to do not know about your industry. You've got to really educate them. That's really the key takeaway is you have to educate them. And with the hidden fees, think about the fees that your clients like to fight about at the end of the project. Okay, the last invoice is the one that everyone fights over. Oh, I want a little bit off of this, or it's more expensive than I thought, or whatever. Think about the things that they don't like. And finally, you always have to be ahead of the money. If it's flat rate, you get paid before you show them the design. You get paid half of it upon signing the contract, the other half before you show them the design, because the work is the design. If you're doing hourly, you get a retainer that's big enough to, I recommend holding it against the last invoice because it's easier to manage from like a bookkeeping standpoint. But if you're billing against it monthly, if you're doing that, you're going to go through that retainer in month one, and now you got to keep asking for another one. I recommend asking for a retainer that is going to cover the last invoice, billing on time. If the client doesn't pay your bill on time, you hold off on doing work, and that retainer should be enough to cover what you project to be the last invoice. Because now, if they just are like, I'm not paying it, you're holding the retainer. It's like a security deposit on an apartment. So that's very important. Clear scope of work, we kind of talked about that. Define your process. So whatever your process is, you have to define it in the contract. So I've seen contracts where the scope is listed. We're going to do all these things, and we're going to design your space. But they don't explain like what that looks like. So what's the first meeting? Where does it take place? What does the design process look like? How many changes can they make? What does procurement look like? What timelines does the client have to follow? If you present something to them in the design phase, like when do you expect a response? Do you want all the feedback at once, or are you okay getting it piecemeal? What does that look like? You have to say it. I know what this is, because everybody's like, 2 revisions are included. Send it all in one email or tell me all at one meeting within 7 days. These are things that are the repeat problems because the client doesn't get it. And when you think of the client, they're super excited because it's a creative process. They're happy. This is like their fun thing. They don't view it as like work. They're like, yes, we could have fun now. And fun doesn't have boundaries. Fun is fun. You have to explain to them, like, yes, it's fun, but we have a process we follow, and you're part of it, and I need your timely input. And by the way, when you ask for them to respond in a timely fashion, no, you tell them to respond in 7 days, a number. Because if you say timely, it's just like, what's reasonable? What's reasonable? What's timely? Guess what? It's going to be the person who's like paying who's going to define it. But you have to say a number of days, for sure. Execution, and one very important one that no one has in their contract ever is the closeout. And what do I mean by that? Closeout is just another step of the process where you're going to say, hey guys, hey client, project's done. We're done. Here's everything. If you call me, it's a new contract. Like this is it. You're done. You're exiting. And the reason that's so important is because you all get so intertwined in the lives of these people, and they're going to miss you. And when you start pulling away, that's when things start to get messy, because they're like actually offended that you've moved on to other new friends, clients. So you've got to like gently kind of tell them there's going to be a breakup coming, and this is what it looks like. And I'm going to miss you. You were so awesome. Hopefully we can meet for coffee. Like whatever it looks like for you, do it. But don't skip that step. It could be a handwritten note, one line. Thank you so much. We really appreciated working with you. Our contract is now closed out. Boom. It's done. But you have to do that. The other reason you do that is if you don't do it, they view it as just still sitting there open. And now if you're hourly and they come back a year later, they want you to honor the same rates. Those rates need to change every year. So you need to have, that's like another trigger for starting a new contract. I recommend, but it's not required, but sign-off sheets for each phase. So like procurement, if you're doing procurement, you're going to have them sign off on everything they're buying. But like, let's say you're saying you're going to buy all this stuff, get them to sign off on it so that literally like sign a piece of paper so there's no question about what you're buying. And that kind of thing, like you want to kind of reaffirm throughout the contract what you're doing and that you have their buy-in. So if you have like a one-page sign-off where you just kind of summarize where you are at the moment, that improves communication. I'm not saying it's doing anything even more for you legally, but it's improving the communication with the client and managing their expectations. The risk shifting that we talked about. So the cash flow is like one of the biggest risks, because if you don't have the cash flow, then you're in the position of having to be the collector of the money. And it's very hard because most of the money you're collecting is small. Oh, what did I do? Small dollar amounts, okay? Indemnification limit of liability, that is basically saying that, for example, you've got the workers, right? You've got the contractors that work for the client, but you're sort of not supervising, but you're managing the design process. You're overseeing their execution of the design process. Your contract has to very clearly say you are not responsible for those people, even though you're in there telling them what to do. So that's, your client is going to indemnify you for anything that comes from their people. It just means they're going to be responsible. They're going to reimburse you for any issues that arise because of their workers. We talked about the limit of liability. Consequential damages means lost profits. So in a commercial project, like I said, the coffee shop that can't open on the projected opening day because your bar stools didn't come in. What happens? Whose fault is it? You have to specifically say, designer's not responsible for lost profits or consequential damages for any reason, because you can be held liable if you don't expressly say you're not liable for lost profits. The warranty, designer typically has no warranty obligation except passing through anything that the manufacturers offer. So that's a standard position. It can be very hard for a client to understand that, but you're not going to provide a warranty on your services because let's say that they say you didn't meet the standard for performance or you breached your warranty. What are you supposed to do? Re-perform? you can't redesign just because they don't think that you did it at the level you were supposed to. So I go even further in the warranty and say that not only is there no warranty provided, but design work is very subjective, and your taste could change. And if you don't like what we ultimately do, we are not responsible. That's really, you have a creative license. That's what it is, and you have to be able to exercise that. Insurance. Most issues that happen on a job site, let's call it, the home, happen at the home, right? And usually in these cases, everybody's got homeowners insurance. So typically, the homeowners insurance will cover like if somebody gets injured, but you have to have insurance too. So really quickly, everyone always asks me, isn't that what my LLC covers? And I'm like, all right, listen, your LLC protects you from you being sued and your personal assets being impacted, okay? Your insurance protects you, your business insurance protects you. If you get sued, if your business gets sued, you're not calling me to defend it, you're calling your insurance company to hire the lawyer. So your LLC protects you as an individual, but you can't hold up that piece of paper if you get sued. That's not gonna do anything, okay? The insurance is gonna actually defend the lawsuit. So the insurance is important. If you don't have it, get a general insurance policy for business. Very important. And also get professional liability insurance, because if you make an error in your work, and let's say everything's built to a number or some elevation or something you did, and it's wrong, your PL will cover you. So you've got business insurance, you've got professional liability. Very important. And I'm not gonna ask for hands, because more people than not, when I talk to them, tell me they don't have it. So I tell them, go out and get it. As a matter of fact, get it before you improve your contract. Just get it. But do both. So the insurance is very important. It's the deep pockets in the event something really bad happens, and it protects you. We talked about the force majeure, the delays beyond your control. I also, the inspection of items, like you should make sure that when things are received, typically your receiver is going to do most of it, but you want to tell your client, when it's in your house, you've got to tell me within 48 hours if there's an issue. Because if they're telling you 2 weeks later there's an issue, we know there's a lot of things that can happen in those 2 weeks. You want to catch any issue they're raising immediately. And if your contract says 48 hours, it's like a cutoff. So you don't want the situation where their kid spilled juice on the sofa and it's a week later and they're like, oh, we don't like the fabric. The fabric isn't a good quality. You know, if you've got a 48-hour window there, it's like, why didn't you tell me sooner? You waited 2 weeks to tell me. It's not that you don't like the fabric, it's that your kid spilled soda or glue or slime, not the slime. So yes, I have kids. So the one thing, this is an interesting one. There's not a way really to protect against the vendor uncertainty. So like the Mitchell Gold situation, right? I can't tell you to address it in your contract, because it's like, on the one hand, you're telling them like, hey, I'm your store, I'm selling you everything. And you know, you're gonna pay me all these amounts. On the other hand, in this case, like I've had people say, well, can I just keep the money? Like they want their money back, but I don't have the sofa, it's $20,000, what do I do? That is a really tricky situation, because you can't shift that risk back to the client. Like they thought they were buying a sofa from you, now it's gone, you know, nothing happened. So the way that got resolved for the people who were successful were they either had really good relationships with their reps who were able to figure things out, or their banks were the ones that helped them in that situation. So even, I had clients who called me like, I put $30,000 on a debit card with Mitchell Gold, debit. Like I can't stop the payment. They ended up going back to their bank, because they had a good bank relationship. The bank was able to somehow reverse it. I didn't even know that was possible. So that was the way. But a lot of people did lose, but the bank was the hero in that situation. So when you find your lawyer, your accountant, your insurance broker, build the relationship with the bank. It's not just an account. Go there and meet the person, okay? Because they can help in these weird situations. Obviously, you need to vet your vendors, but there's things you're never going to be able to figure out. I will say this, as far as a delay in that Mitchell Gold situation, that would fall under the force majeure, like, hey, I couldn't get you the sofa. In that kind of situation, you've got to say, look, I don't know how to handle it. We're going to work on it together. Give me some time, and then work it out. Try to work it out. But a lot of people did lose in that, and there's not like a simple solution. If anyone had experience and wants to share it, like a positive outcome, please do. But that's a tricky one. So that's a risk that you're taking, really, you know, because you're the one that's selecting the vendors. So it's tough. Nobody ever would think that would happen. Off the shelf, like why off the shelf isn't the best? This is just the template. I kind of like talked about this where basically, typically, if you're buying a template, there's just stuff in there that isn't custom to you, and you guys are all selling custom things. Like, your contract should really be tailored to how you work. So I am a big fan of having some type of contract. So if you have a template or it's something you put together or you got it from this person or you chat GPT'd it, it's something. It's something. It's better than nothing, okay? But if you have the opportunity, try to get something that matches how you work, okay? And the thing is, you'll never be comfortable explaining that contract because it's not yours. You know, you cobbled it together. You don't own it. When you know that it matches how you work, it's instinctively, you instinctively know what the contract says. So when there's a problem, you don't want to have to say, well, let me see what my contract says. You want to just know what you're going to do, and you want to know your contract backs you up. And the other thing is with that, if you just grab a template, you don't see the gaps. Like, you don't know what's not in there. So it's worth the investment to get one that matches how you work and review it every like 5 years, maybe, or less. The format that I recommend is a letter of agreement, like a cover letter. Dear client, it's so great to have the opportunity to work with you. We loved visiting with you. Attached, please find, our terms and conditions and scope of work. It outlines how we work. If you, please sign and send in your check, and we're looking forward to getting started. It's something like that. It's a cover letter because it's personal, and you're writing it personally, and you're saying we and you, and then you're saying client and designer, but you're starting with me, we and you, and you're going to, in the first few pages, talk about the scope and the pricing, because that's all they're looking for at first. So your letter of agreement should be like, this is what we're doing, this is what it costs. Attached as attachment A is the terms and conditions, because they're going to read the letter, see the pricing, oh, that looks fair, pause. Then maybe later they'll read the legal terms and conditions. So at least there's a natural pause. You later are going to review everything with them to ensure that they read the terms and conditions, but at least you have all the pricing up front and the scope, because that's all they're looking for. The digital tools, the DocuSign, Studio Designer, whatever, those are really helpful because they help manage things. I do like that, but I do encourage people to sit down and do it in person. And I say make it pretty, because what do you guys do? You make things pretty. So I always recommend take your document, put it in landscape format, add photos, put a border, make it match your marketing. So like whatever your marketing package that you give to people looks like, use the same template and put the contract into it. Put in a picture of what execution looks like. I've got one client that's got a big smiling face throughout that contract. And think about it, when you're a little kid and you get a book, if your book has 6 pictures in it, it's a book this thick, what's the first thing you look at? Pictures. Even as an adult, if I get a book and it's got pictures, I'm definitely going to look at the pictures. I might never even read the book, but I'm going to definitely know what those pictures are. So use those as a way to communicate with your client too. And they're not taking the place of anything, but they're setting a tone of this is a positive thing. It's not a scary contract. It's just looks just like the other stuff. Oh, okay, this looks good. Yeah.
I feel like in this part, one of the things I've noticed time and time again over the last couple of years, when you have a designer or a firm that is operating at such a high level, sitting down with those clients, they're coming to you because you're very important to them. But the vast majority of those of us out there, the client is more of a priority. So you have the husband who doesn't want to show up to the first meeting. You have the wife who doesn't want to read something, yada, yada. Going through line by line with them, while it seems appropriate, sometimes, like we have a whole FAQ document that is
That's
branded.
helpful.
It's
Yep.
branded and you have to initial, you read the FAQ document.
I'm a fan of those.
I think it's great. The problem is, they never read it.
They don't read the FAQ?
They refuse to read it, and because they're too busy, and so they've read the contract, which is a 2-pager, which we're going to increase, but the FAQ, which is meant to be a picture book to make it easy,
Exactly.
I will say, like, well, you signed off that you read it. They're like, oh, I never went through
No, that's an excuse they use.
It's a terrible excuse.
Yep.
So how do you brand that? Because I feel like all of this I buy into, but how do you brand that at the very beginning of like, this is a serious document, and also, although we're doing these creative fun things, there's a big difference there between the, very large designers, big name designers, who can say, we're gonna sit down and do this, versus the majority of us who are probably, you have very important clientele. The sports player isn't gonna read that.
Yeah.
Their lawyer might. How would you?
Well, once they sign it, they're signing on to it. So it's in their best interest to read it. And the thing is, you do have to assume they're not reading it, which is awful. The FAQ is huge. I say all the time, like, okay, don't use ChatGPT for your contract, but take your contract and dump it in there and have it write an FAQ. Every single time, because there's a better chance they're going to read that. You really have to explain the big issues to them. Like, you might not go line by line, but you got to go over the big ones, the ones that hit them in the pocketbook. You have to. You've got to find a way to talk to them about it and make sure they're nodding and understanding, because the minute they sign it, they're saying they've accepted it. On the husband-wife issue, I put into the contract, into the legal terms, I put a representation that everybody, meaning husband and wife, that is bound by the agreement has read it. Because that's a ploy. They're doing this on purpose. They're setting it up to say, my husband couldn't be here, so it's good cop, bad cop. Because when the dispute arises, they'll be like, my husband wasn't part of that conversation. Well, too damn bad. You represent him. You are one. So we put that in there so whoever's making the decision represents that they have the authority of everyone who has an interest in the property. Not just the husband. Maybe their parents own it, own the house. So you've got to get some sort of head nod is what it is. But they're legally bound the minute they sign it, even if they didn't read it. I'm just saying, try to get them to read it for communication's sake, Question. From the husband? Yeah, that's asking for trouble.
And I said, well, I said, no. And no, for a lot of reasons. I don't know how we were going to do this in secret. Was I going to wear a wig over? Were we meeting for coffee and I came in this kind of,
Right.
I wasn't
Trench coat.
I already met him. He was at the consultation. Now we're going to secrecy, how I was going to pull that off. But is it necessary that both parties, so I'm working with a wife right now. I've met her husband. He's completely on board. He's just a hands-off kind of guy. Doesn't want to talk about design. And does he need to sign this as well?
You know what? Probably not. But the big but is this. If you get a dispute, the first thing they're going to say is, he didn't consent to it. So you just want to do these things to make it easier so you can win the fight. So it's better if you just get the 2 signatures. And if you can't get the 2 signatures, I add one line that says, I represent that everybody, a representation, meaning if they misrepresent, they lied to you to get you to sign it. So I'm like, just have one person sign it, but add the representation. I represent, meaning the opposite is I misrepresent. So I represent that my husband has read this. Okay, and he's on board. Yep, there's like a bunch of things. I even say I represent that I understand the pricing. Those are big things. A representation is stronger than a promise in a contract because, again, misrepresentations, I'm lying to get you to do this with me. So there's a question right behind. What? No. That's just them trying to take from you. Just say no, because they're trying to get something there, some sort of like extra, yeah, and they're going to put 10% on it or something for the warranty. So no, and the thing is, don't let the confidence and like bully-ishness of the builder get you. Is he playing nice? Is he playing nice? Be firm. Be firm, because they win in these situations, and it's because of their attitude. You do not see me speaking to a room of general contractors telling them to have boundaries, okay? But you learn from them. Learn from them and be firm and just say, no, we have a contract. No. If he wants to sell a separate contract to like wrap it, it's called, like he can still provide a warranty. He can even charge more because he didn't procure it. But he's going to install. He's not providing the warranty on the fixture. He's providing the warranty on the installation. He can still charge for it. You can say, I'll inspect everything and warranty to you that I inspected it. You know what I mean? But no, do not fall. Those builders, you would all benefit by learning from how they operate, because they don't take anything from these clients. Nothing. And the client's like, yeah, okay, builder, whatever you say. My designer's bad, and you're strong and smart. It's crazy. In that fight, the builder wins all the time. So you've got to really go against them. I get the relationship, but they will respect you more. And honestly, do you want a relationship with someone who's going to be taking from you constantly? No. So. Yeah, and don't let the client give your contract to the builder. That's just some practical advice. I've seen bad things come from that. Yeah, those builders, they're out for themselves. I mean, I hate to trash a whole industry, but I've seen, again, too much of the dynamic, because the designers are very like good-hearted, kind people that want the best for the client. That's not how I describe a builder. Okay, they want for the builder. Change order, change order, change order, change order. Deplete the budget that goes to design. That is what happens. So be firm, because they're going to keep, and if you give in, there's going to be more. Yeah. Yep. Yep. They can change your design. They can change your design too. So you've got to tell the client up front, like, no. I mean, listen, you've got to say, this is my design. I'm not overseeing your people. Okay, those are your people. But I'm there to make sure the design is implemented. You're paying me a lot of money for my thoughts and the design. Okay, I'm trained at this. I have background in it. You're going to listen to me with that. And there's going to be a time. You could say there's going to be a time where the builder's going to question what I'm doing. You've got to put your trust in me. I've had that happen with high-level designers, that this like builder with no staff changed their design. I mean, are you kidding me? These are things that are going to be in a book, And he's like, now I can't put it in the book because that's crap. I don't want to do that. That's not my design. So think about it. Like, they know no bounds. No bounds. So. That's the most important part. Yep. That's great. I think that's great. I do. I just think the key with all of it is to make sure that it's clear to everyone that you're not managing that contractor. Because nothing good comes of that. And I know some people have that in their model, and I'm not trying to like slap you on the wrist, but it's just not ideal. I know a lot of designers will even get the GC license. It's honestly not worth it. It's not worth it. And the ones I've seen do it, it just ends in bad. It just ends bad. That's it. I want to get through a few more things, but keep asking the questions. We talked about the page turn, so I'm not going to go through it too much, but you definitely want to provide examples of what every provision means. So to your question, when you have the client that's like an athlete or something, is just not reading it, you want to say, okay, fine, you don't want to read this section about whatever. Here's an example of what happens. And just talk about the examples, because they will go back and remember the example and not the words. So I call it illustrations. So best practices, and after this, it's really the design checklist. So this is the last like real substantive slide. Best practices and red flags. So in addition to the essentials, we could have an entire hour on IP, okay, intellectual property, whether it's your design, your stuff, your, everything. Also, photography agreements, that's separate, it's not a client agreement. What's intellectual property? Intellectual property is the things that are not tangible, that are valuable. And you want to protect it. So a few ways that you're going to be thinking about IP. If you terminate, these are just like kind of throwing it out there to think about. If you terminate the client, and what are you going to give them? Are you going to give them everything and let another designer execute? If so, what does that look like? What language is around that? If they fire you and they demand that you give them the package of stuff you've done, are you okay with that? What does that look like? Who has liability? If you get fired like halfway through executing a project and another designer steps in, are you going to allow your client to allow that designer to photograph the project and take credit for it? Stuff like that. There's a lot of little questions around that, and it's very current in current events in this industry. You got to just think it all through. I have people who are just like, I'm not giving them anything if they fire us, nothing. But if I fire them, I'll give them everything. So you have to think about what works for you and it's really, I think, like a case by case of what's fair. I do think if you fire the client and they're paying you a ton of money, you should give them stuff. But you should put some parameters around, what they can do with it. So design against advice. This is the situation where you tell the client, no, you should not proceed with this particular design, but they really want it. And you're like, no, I'm telling you it's a bad idea. No, we want it. You get them to sign a one piece of paper, one page document that says, we have advised you that this is bad. We don't recommend it, but you're proceeding anyway and telling us to do it. We're doing it with no liability to us. Design against advice. Just sign that one page. The reputation protections are the ones we talked about, the non-disparagement. Confidentiality should expand to include your pricing, your vendor relationships, and any disputes. Now, one thing I like to put in is to say that in no event can the client reach out to one of your vendors and say, hey, I work with ABC Design. I'm working with them. Can you please tell me more about the pricing? Now, in my last panel, I had an actual vendor say, when this situation happens, what can we do? What can we do to help the designer? And we were just like, just have our backs, you know what I mean? Because don't give the client access to that information. Your contract needs to prevent the client from doing that kind of thing, because they will do it. Stay out of court. So I did say really quickly, I recommend arbitration. Very quickly. Arbitration is a private judge that you hire to resolve a dispute. Mediation is a private person you hire to help come to a compromise. That person cannot choose a winner and loser. So where you see mediation, that's not the end. Arbitration is the only way you get a final decision outside of court, okay? So I recommend arbitration. I go a step further and say that the two parties will pick one arbitrator that has experience in construction and interior design contracts. Because now you're picking an arbitrator that you know knows the industry. And if you have a good contract and they know the industry, you're not going to have a situation where they look at it and say, designers make this much money? I thought they just picked pillows. Like there's a huge misconception out there about what you do. And you don't want to spend a day educating the person who's going to decide your dispute on what value you bring to this transaction. Because they could come in very biased. So pick somebody that, make it a requirement that they have experience. We talked about the photos. I do write in a provision that says, if you deny us the opportunity to photograph, we're going to charge a flat fee, liquidated damages, that's contractor language, of 5, 10, 15. Somebody just wrote in $20,000, okay? Now, the point here is that when you have that number in the contract and you're going through it, they might not ask any questions about the contract, but if they see $20,000 in there, they're gonna say, wait a second, you're charging me $20,000 if I don't let you photograph the project? And you're gonna say, yeah, but I don't see that happening because you just told me that you're gonna let me photograph it. So as long as you let me photograph it as we've agreed, that should mean nothing to you. So it's only there if you're a bad boy or girl. So don't be a bad boy or girl. I mean, a lot of this is giving structure to, just like little kids, you're giving them a structure. Because again, it's a very creative, fun process for them, and you've got to remind them that it's not open play, Annual rate adjustment, your hourly rates go up every year. Every year. And then communication policy is, our business hours are 9 to 5. Please email us. We don't text by design. Whatever your policy is. I've seen some really great policies that are very specific to the businesses. And then, red flags. I mean, you know what they are. I mean, it's just, I should change that slide to say trust your gut, because it's something that gets developed over time, but you know it. Like once you have that gut feeling, trust it. One thing I don't have on the slide that I'm gonna update is that one thing I've started to add, and I promise it's the last slide except for the checklist. People always call me and say, how do I get my client to not delay the process and to make quicker decisions? And what I do is I write in that if they delay the project or suspend the project or whatever, do something to kind of slow the process down, they get charged a fee. So if they are not responding in the 7 days, on the 10th day, you're going to send them a bill for $200 because you did not respond. Again, they're going to see the number 200 and say, what is the 200 for? You're going to say, listen, I don't want to ever send you a bill for $200 for you not responding, so just respond on time. So it's a slap on the wrist for them being delayed. If they suspend your project, you're going to charge them a suspension fee or a demobilization because now you're putting off the project till next year or whatever they asked for. Those are words that contractors use. Demobilization, remobilization. Use the vernacular of that industry because they get what they want. So if you do the same thing, the client will listen. This slide is my checklist. And I'm going, like I said, I will email it to anyone. You can take a picture, whatever you want. It's the first page. There's 2 pages of it. And basically, you can go through your contract and see if you have everything based on this. I'm going to flip to the next slide in a minute. And I'll go back. Here's another page. And I use the same exact one when I do my reviews. And then another page. If you give me your email address, I'll email it. Mm-hmm. Yeah, I would give it to here, but no, I don't know who to give it to. So, but if Universal can have it too. And then ask me anything, and which you have. And then that's me. I'm on Instagram. That's my cell phone. I give out my cell phone. You could text me. But I'm on Instagram. I'm part of the interior design community with Lori Leisure. So I'm one of her board members. And, I do work with designers. I'm not here to sell any of that. I'm here to help you. So you can ask me anything and reach out anytime. Thank you for your time. I'm sorry. I feel like I could go on for like 2 hours more. I really could. And, yeah. So, but I'll be here right now. If you want credit, just sign the paper that's going around. And I have copies. I had an article in Business of Home, and I have some printouts of that about contracts, so that's up here. I have like 3 business cards, so just follow me on Instagram. So, but thank you very much, and I appreciate all the great questions. So, thank you.